Welcome to the Spot On Insurance podcast, brought to you by Insurance Licensing Services of America, ILSA. This is Arlene Tavares.
And this is Ted Tavares coming to you from Puerto Rico. In this episode, we'll be getting insight from one of the top regulatory attorneys in our industry.
But before we begin, remember to click on the subscribe button so you don't miss a single episode. And now here's our host, Doug Foresta.
Hello and welcome to Spot On Insurance. This is your host, Doug Foresta. With me today is Dan Maher. So today we're going to talk about E&O exposure and issues that make for compliance problems. Let me first say a little bit about Dan, and then I'll bring him right on. Dan Maher is the Executive Director of the Excess Line Association of New York, or Eleni. He is an attorney licensed to practice in the states of New Jersey and New York and a number of federal courts. And prior to joining Eleni, he was the Senior Vice President and General Counsel with Lancer Insurance Company for 15 years. Dan Maher, thank you so much for joining me.
Well, it's my pleasure. Thank you.
Well, let's start with fines and compliance issues. So, as I said, I know that today we're going to be talking about exposure and issues that make for compliance problems. So, I thought we could start with this. Can you explain, perhaps in general, what people need to look out for when it comes to fines and compliance?
Well, absolutely. And, I want to start and kick off by telling the audience that I dedicate this podcast to all of you who became compliance people in the insurance area in the same manner that a lot of people have learned how to swim, which is getting shoved off the dock and told, here you go. Because unfortunately, there's often a lack of training in the area of compliance and fine avoidance, because a brokerage business makes their living by placing business, and the regulatory issues and the compliance issues, their requirements, but the broker focus is usually on trying to meet the client's insurance needs, and the compliance requirements and regulatory issues often don't come out until a mistake is made, and that's probably a bit of bad planning. So hopefully, what we can talk about in this podcast is ways to engage in a little bit of a preventative medicine, or as I like to say in football, to deal with the fundamentals and avoid the fumbles and the interceptions. So with that, Doug, if you'd like me to, I'll just talk a little bit about where do you get started on compliance and discipline avoidance.
Yes, that would be great.
Okay, so let me start with the fact that it's in the beginning there was licensing, and that's probably the first place where brokers make some mistakes. You have to be licensed in any state where you're selling, soliciting, or negotiating business, and even that can be a little bit of a problem. But let me start with the real fundamental. The first thing any new brokerage needs to do is to make sure they obtain and hold the licenses that are necessary in their home state, the resident state of where the operation resides. And then if you also operate as a non-resident in other states, you want to make sure you have those licenses as well. And even there, sometimes mistakes are made, because in some states, licenses are issued to entities when a business is operating as a corporation or a limited liability company. And in some states, even if you're operating that way, you can only license individuals. So even that dynamic is inconsistent among the states and kind of creates some issues. But, in the big picture, let me start by saying, you need to be properly licensed in any state where you're going to be, placing business either on the admitted side, and if you're also placing non-admitted business, excess and surplus lines business, you want to make sure you are properly licensed to do that. I'll talk a little bit about E&S regulation in the sense that it differs a bit from placing business in the admitted market, but I'll do that a little later in the podcast. So real basics. One, am I licensed in the state where I'm doing business? Am I properly licensed? First big issue. That doesn't seem like that big of an issue, but it's probably one of the first places where you'll see brokers get fined. What else? Well, if you, in most states, if you are a licensed agent or broker, you must set up fiduciary bank accounts. It's fundamental. Some states don't require it, but if you're licensed in a state that doesn't require it as your home state or your resident state, and then some other state requires it, you may nevertheless have to set up those fiduciary accounts. And why is that important? If I told you one of the biggest areas where I see fines in New York is when a brand new broker sets up shop and they bounce a check. If you bounce a trust account check, that in New York may lead to you being out of business before you even got in business, because bounce checks are often an immediate license revocation here in New York. So as fundamental as it is, that is one of the things that you'll find. So handling the money that you receive from insureds to provide to insurance carriers is a big issue. Another thing that leads to substantial discipline by a regulator is if you issue evidence of coverage anticipating that the insurance company is going to agree with what you proposed, but before they've actually agreed to it. Because if you issue an insured evidence of coverage which has not really been placed and anything goes wrong, that's a big area for discipline too. So that's something to be aware of. Other areas, and again, very simple stuff. And this is like how to avoid the fumbles, right?
Yeah.
Just simple issues are failing to tell a regulator or all regulators when you've changed the address of the licensee. Almost every state says you have to notify us within X days, usually something like 10 to 30 days. So that's important. If you fail to report to other states, say you got fined in the state of Iowa, and you don't tell all the other regulators that licensed you in a set amount of time that you've been fined by one state, you'll get fined for not telling them that you've been fined. I know that's that's almost like fine squared.
So let me slow you down for a moment. Let's say I'm regulated in 30 states and I get fined in New York. So I need to alert all the other states. And is that in writing, I assume?
That would be correct. And I'll give you an example. One of the worst examples, painful examples, was that one broker failed to report to one state that they had no excess and surplus lines business to report. So that's called a zero tax return. You have to tell them, I didn't do any business in your state, and therefore I owe you no taxes. Because they failed to file a zero tax return saying I didn't do any business in your state this period, that regulator fined the broker. Then the broker got fined by other states because he failed to tell the other states that he had been fined for failing to tell a state that he did no business in that state during the appropriate period.
Spot on Insurance is sponsored by ILSA, Insurance Licensing Services of America, America's premier insurance licensing experts. To learn more about ILSA and the services they provide, visit ilsainc.com. Dan, when you talk about fines, are these significant fines? I mean, how much in terms of dollar amount are we talking about? I mean, how much could this add up to potentially?
That's a great question. And most recent fine I saw was a broker failed to tell a New York regulator that its license had been revoked by the state of Indiana. And it seemed like the revocation was more administrative, but in fact, it was a revocation, and they were fined $3,000. So the first fine is usually not a money killer. It's not going to usually put an otherwise successful brokerage out of business. The concern you have is that once you have been fined, every time you complete another license application, you have to tell the states that you've been fined. And that, it's at least a 5-year reporting period for that. And sometimes it's even more. So your two big issues with ever getting fined is, number one, it creates more reporting requirements with respect to all your other licenses. And number two, it because of that perpetual reporting issue, it adds work, and also it's like strike one. So in other words, if I got fined once strike one. If I get fined twice, strike two. If you get fined a third time, you could be looking at something more serious. And I'm not talking about just more in monetary penalties, but you could have a license suspension or revocation, and that will put you out of business potentially. So that's why you don't want to get fined at all. You don't want to be in that crosshairs of the regulators.
Right. That makes sense. And of course, I know our listeners don't want to even accumulate, $3,000 in fines, but it's not so much just the money that you're being fined is what I hear you saying, but where it's going to lead you in terms of your business.
That's right.
Let's talk about the role of consumer complaints. Can you say a little bit about consumer complaints and the connection between those complaints and the process of regulation?
Again, it's a very timely question for a podcast like this. If you're a broker and you have a fight with a carrier or another broker or a premium finance company where it's really let's say it's a commercial dispute among the people in the business, the regulators, at least in New York, so if I'm complaining as a broker that I got, mistreated by a carrier or a premium finance company, the regulators, I hate to say it, but it's more an attitude of like, well, suck it up. You're in the business, figure it out yourself, right? But when a consumer complains, now, the consumer would often either be the insured or a potential claimant. And when a consumer complains, that's what the regulators jump on. So you'll get a letter, and it could be a complaint that you might think is meritless, but you may have to spend some time. And I would suggest that when you hear from a regulator and they're asking you for a copy of your file or they're asking you to respond within 10 days, that you do try to communicate with them. And even if it's to say, we received your letter, it says respond in 10 days. We are, I'm going to ask for a little bit more time because we're trying to pull all the documents together that we need. But, we have every intention of fully cooperating with your investigation. That's what the regulators really would want to expect. If you put them off and you don't bother to respond, you've probably compounded the situation. Because what you don't want to do is anger regulators for non-responding to something that may not even be that big a deal. So you set yourself back. So you want to avoid consumer complaints. And, that is just like any other business. You take care of your business as best you can. If somebody feels that they were wrongfully denied a claim, you can say you agree or disagree with their position. But the bottom line is, you're not making the coverage calls. Usually that's the insurance company. But you want to make sure that you're communicating properly and timely with the regulators. That would be the biggest single piece of advice I would give somebody.
Thank you. I realized that I described at the beginning that you work at Eleni. Can you say a little bit about Eleni, what it is and the work that you do there?
Eleni, or the Excess Line Association of New York, is one of 15 state stamping or service offices that are essentially been created in New York. Eleni is created by statute. We are not a governmental entity per se, but we are created by statute. And our job is to help the brokers. It's to facilitate and encourage compliance with the laws. The excess and surplus lines laws of the states are a bit more complex than just the general insurance laws applicable to agents and brokers. Our brokers deal with the more complex and difficult risks, and complying can be, it's a different method of complying. So our job is to help teach the brokers how to comply, help them avoid the mistakes that could get them into trouble with regulators. We provide educational facilities, and certainly one of the things I would tell everybody that hears this podcast, we're here as a service organization. As I said, 14 other states have similar organizations, and I encourage you to contact us when you need help in our given states. We can help you through, go to meetings over the internet. We have videos and other information on our website. We have a help desk that is there to assist with, the technical electronic filing system, and also to respond to any questions that you may have. That's what we're here for, to service the brokers and assist them. So I encourage those that would hear this podcast to utilize the services we provide.
Thanks so much, Dan. My last question for you is about E&O issues, particularly notice failures. Can you say a little bit about that?
Absolutely. E&O, or errors and omissions, is the insurance that brokers buy, that if they fail to do what they are legally responsible to do as brokers, and it causes damages to their insureds, that is the insurance that responds to the broker, to protect the broker and possibly indemnify him for losses he might have caused an insured. The errors and omissions area is a little different than regulatory compliance. I would say under New York law, I'm probably similar in most states. The fundamental law of the land is that a broker has the duty to acquire the coverage sought by the insured within a reasonable amount of time, or to inform the insured of his inability to obtain that insurance. So fundamentally, E&O coverage and errors and omissions are largely about the failure of a broker to obtain the coverage sought by the insured. That probably is the largest area of loss exposure they have. But one of the things I was going to add, and if I die and I come back as a practicing attorney again, I think what I want is all the cases that involve bad notices. And the reason I say that is they seem like chip shot type cases, but it's amazing how many areas or points of failure exist for not getting a notice. And that can be a notice of cancellation where it's required, or a notice of non-renewal, or a notice of claim, or a notice that a policy has been reinstated. The failure to provide the various notices that are asserted or required in an insurance policy or by law is a ripe area for litigation. And brokers and agents, it's a real fundamental, but it's a fumble if you don't provide the notice, or you send it to an old address, or for any other reason you just fail to provide the notice as required by law. I'll tell you one quick story that was interesting. I saw a case. A broker asked me for some help, and it involved what they thought was their own failure to provide a proper notice to the insurer with regard to a claim, and the insurer asserted that it was late notice and they were going to deny the claim. Well, it turned out the insurer itself had put a cover letter on the policy, and the cover letter said that in the unlikely event that you should have a claim, please provide your agent a notice of the claim. So the insurer themselves created an ambiguity, because the policy said provide a claim notice this way. But now the first document the insured is going to read says just provide the notice to your broker or producer. So essentially that was done, and then the court said, well, you told them two different ways to make a claim, so it wasn't late notice because they did what you told them to do in the cover letter. So that's how ironic things can be, and if in terms of ambiguities and in terms of not giving proper notice, that's so fundamental, but it's a mistake that's often made.
Great takeaways and really important things to keep in mind. Again, my guest today has been Dan Maher from Eleni. Dan, how can people reach you? What's the best way for them to find out more about you and about Eleni?
Well, three ways. Our phone number here is 646-292-5500. Our website, www.eleni.org, is chock full of information. Or you can email us at the Eleni Help Desk, or me directly, dmaher@eleni.org. So we're happy to help. So please contact us if we can.
Dan Maher, thank you for coming on the show and for sharing your words of wisdom with us.
By the way, our show notes and bonus resources can be found on spotoninsurance.com. Subscribe now so you don't miss a single episode.
Thanks for joining us. And don't forget, we'll be answering this week's podcast questions at Spot On Insurance Facebook Live, Fridays at 11 a.m. Eastern.